All right. Hello, everyone. This is a mini review of our material covered this quarter and best ways to study for the final exam for business law, Business 201. And I wanted to start this page you're seeing here, final exam studying hints. I will post for you on our website, on the Blackboard website, in course resources. I will make reference to that. You should see that also in an announcement and an email to all of you. Excuse me, I don't mean to cough in that recording. And so this is just some basic hints and ways to start looking at this great volume of material we've covered this quarter. Remember, your exam is open book, open notes, and just nothing electronic that you can have during the exam time, just as you've seen in your other two quizzes. And obviously I can't test on everything. The focus that I want you to really pay attention to is about from the midterm on, meaning from torts, which is negligence and strict liability, criminal law, contracts, and property law, and employment law. That section is what we'll be mostly leaning towards for this. You also need to know, however, basic concepts certainly before the midterm time of the quarter, so you should understand some basics about constitutional law and our system of law and ethics, and that. I'll go into a little more detail again in a second what I'm expecting of you there, but the emphasis will be from torts onward that I will be testing you on. There will be, I'm still in the process of drafting up your exam, but the final exam will be at least 3, maybe 4 short answer questions and 1 essay. And that's will be 100 points. The bulk of your final exam score, 60 points out of that 100 points, will be coming from your essay. So I will go through again the best way to work on this from a legal reasoning and critical thinking sort of perspective. I'll go through that in a short PowerPoint here, which we've talked about in class. I won't spend a lot of time on it, but just to sort of refresh your minds of how best to analyze the cases when you have that. You also need to remember that you have you expect one of your 4 short answer questions to pertain directly to our mock trial, okay? So you need to go over any notes you had during the trial. You need to go over the final verdict form that was delivered by the jury. In one of your classes was a jury verdict form. The other class was a court judge decision that I made, and so all those you'll need to go over that form in particular. In addition to that, you should also remember what you've done on your service learning presentation. You had some significant issues you had to come up with there, legal issues and connections between your service and class. So you'll should expect to see a question that's going to be dealing with that short answer, one of the short answer questions that'll be dealing with that process as well. So connecting the dots between service learning and concepts that we've talked about this quarter. So again, the best way to study, in my opinion, for this, since the bulk of my emphasis for you here is to be able to apply the material. The first 3 points here all deal with case law, and particularly looking at the weekly cases we discussed this quarter. It's particularly the ones we discussed at the beginning of class each day, so that if you look at those again, it'll help you on analyzing how we analyze and how the courts analyze the legal issues involved in each case and how they arrived at their decision. If you look at the end of each chapter in the textbook, there is a section that details what are called case problems. If you can practice some of those, again, that's decide how you think the court would decide in those cases. And if you want to verify the decision, if the textbook doesn't provide it for you, go do a quick search for that case. The citation is provided for you at the end of each of those problems. Go do a quick search in Versus Law or findlaw.com or Google for that matter and try to find the case so you can get the decision to check if you're right on that. I've posted, remember, in course resources also the piece that's called How to Brief Cases and Analyze Case Problems, and that's available for you just to, again, refresh your memory. Where people are not getting as high scores as they could on your essays is because you're not fully analyzing the issues that are there and the legal concepts that apply to those legal issues that are present in the cases. So getting a proper format. I'm not grading you just on the format, but I'm grading you on your ability to analyze fully what's at stake in these cases. Okay, so that's the first 3 points here, focusing on case law and critical thinking and that sort of thing. The next piece that I think will be very helpful for you is item number 4 on here is in each chapter in the textbook, you'll see it's highlighted by the author. As you go through, it'll say concept summary. And rather than try to study, go back and restudy the whole amount of material, which is obviously not possible, I would suggest leaf through each of your chapters and just look at the concept summaries. And I've noted here pages 20 and page 32 in the textbook referred to constitutional law principles that are in this concept summary that the authors set out. And it's rather than try to get the whole thing, you've got like 2 or 3 bullet points that can really help you understand, refresh your memory on what the concepts are. And then also at the end of each chapter, you've got this list of terms, key terms. I provided key terms that are in our lecture portion of our website. Although those key terms are much broader than all that are included in this particular textbook, they all pertain to the chapter. I would suggest that at a minimum what you need to do is look at the terms in the chapter, each of the chapters at the back, and be able to understand most of those terms, if not all of them. If you get stuck, of course, as you're studying, you can go look at, like I've got listed for you, dictionary.law.com. The Cornell University College of Law has got a great website that has a legal dictionary on it. And so for terms you get stuck on, they should be in our glossary of our textbook, but if not, which I'd be hard pressed to think that they wouldn't be, you might want to take a look at one of those legal dictionary websites as well to help you as you go through on that. So broadly, the concepts that are in each chapter are what we want to aim at, and that's what you need to study. I'm not testing you on minutia, really obscure details, just being able to understand the concepts and apply them in a case setting. You should be able to do that from all that we've done so far this quarter. So as I note here at the bottom too, it says you will get bonus points to the extent that in your essay and other answers you present clear, concise, and proper use of concepts and terms discussed this quarter. Please don't copy definitions out of the textbook. Use your own words to describe something to show that you understand a particular concept. And the more concepts that you can relate to a particular case, especially in the essay, that will be more points for you as you go through. Okay, on the test. So let me get here for the PowerPoint just to refresh your memory on this. So we went through this critical thinking and legal reasoning PowerPoint in class, and what I think is really important for you to remember out of this is use this as a tool to organize your thinking when you're writing your essay, right? So you can do this in a couple different ways, as we talked about this. This is is one method of doing this, is focusing on what are the facts of the case. So you'll obviously read the facts. You don't have to rewrite them for me. I know what they are. So if you read the facts of the case, then you need to try to identify specifically what are the legal issues that are going on here. I may ask you who should win and why, that type of thing, but what are the legal issues that are at stake? And the holding is more or less the answer to the question that you are addressing in the issue. So how will the court hold or decide, and what's the rule of law that is going to be applied here that helps get to the decision. So the rationale and then the reasoning of the case is essentially the justification for how the court arrives at its decision or its holding. So Is there case law? Is there some prior precedent that's there? Is there some statute that mandates that the court hold a certain way? And so that's what you're going to get at. That's a basic way of analyzing. So you can go through each of those issues that are present in a case and analyze that way. The other way is this IRAC method, which is issue, rule, application, and conclusion. So you start by identifying what the legal issue is, or what the legal issues are in the case. What's the rule that should be applied to them? And the rule obviously would be going back and looking at your textbook, looking at your notes, what types of concepts that apply to this particular legal issue that's being addressed in the case. You then apply it. Here's the rule. Then you apply it and say this is what the outcome should be and why. Okay, and that's the basic way of how you can look at these cases. Now we did this with the slip and fall. Let's put all this up here. Slip and fall case. And where this woman goes in the grocery store, and we talked about this in class, and she slips and falls, and there was no sign or warning that was up there for her, and the floor was wet. And so the question is, the issue here, was the store negligent, and who should win and why? So you could, again, go through the IRAC method, or go through looking at what the relevant facts are, what the legal issue is, the holding, and rationale for that, for each issue that you would see that's present in this case. All right, I'm going to skip forward a second here, so we can go down to another case and just kind of analyze that way. All right. So this was I don't think we actually got to this in class when we were going through this PowerPoint, but suppose that an employer requires that people smile while they're working, and if they don't smile, they're not doing this, they're going to get fired. So obviously, then question here you want to get at here is whether an employer can legally do this, and so that's or is it discriminating somehow? And so one way to answer the issue is, again here, whether this is a discrimination, and whether this can be done lawfully. One way to get at the situation, I would most likely, if I was giving you a case like this, I'd give you some of the precedents and have you examine that. You could actually look through this in the casebook or textbook and find some information that would support the decision on this as well. But suppose I gave you the precedent in this jurisdiction for where this case is taking place is that professional cheerleaders can be required to smile. It's part of their employment, but it has to be specified when they're hired. Okay, in certain businesses, people have to wear clothing or uniforms, and that's consistent within that industry. Then that's something that's acceptable in this particular jurisdiction. We all know that there are many places where people can't be required to lift a certain amount of things without any type of mechanical assistance, and there's a legal requirement, federal legal requirement for that, or whether they're discriminating. So I would invite you in this case, then, I'm not going to give you the answer, but I would say if you want to examine this,
you would want to look at this would be discriminatory in any way. In this case, I'm giving you precedence and saying there's some other types of situations or cases where this is okay. This may ask you to consider a lot of other questions about this. The significant one here, as it says for cheerleaders, is this a similar type of job? A server is a similar type of job as a cheerleader. With cheerleaders in this jurisdiction, it's required that if you're going to make this part of the job description, then you have to tell them when they get hired, essentially. So did the employer of this restaurant or cafe or whatever it is actually mention this to the employee at the time? The key thing I want you to remember when you're doing these analyses of cases, and that is there's rarely, be sure that you fully address all the legal issues or the majority of the legal issues that you see that are present there.
and then apply it.
The legal rule or concepts that you understand from our discussions this quarter and from textbook this quarter, and apply that, and then come up with a decision. Even if I disagree with your ruling in the case, let's say, if you were to be the judge, that doesn't mean you don't get full points. It just means you need to analyze fully what the problem is that's going on. Okay? So that's that, just to refresh your memory on the legal reasoning sort of process. The second thing here is if you look in course resources, actually, I'm sorry, if you look in the lecture tab in our website, you'll see for every chapter there's a chapter review. I have made them all it's revised and updated and put this all into one document. It's 10 pages long. It covers all the chapters we've covered this quarter and gives you bullet points as to essentially the things that you should know from that chapter. I think it would be very helpful for you just to go through this and study this. I will post this for you. Like I said, I'll post this updated version online so you have it available for you. You may bring this to the exam. It's totally fine. Remember I'm testing you on is not that you can memorize that the Employee Retirement Income Security Act regulates private pension plans, for example, on number 14 here. I'm not testing you on that. It's not a multiple choice exam. I'm testing you on how you could apply these things. We discussed this, the Civil Rights Act of 1964. We clearly discussed in class when we talked about employment law. How does that apply in a real life setting? That's what you're getting at. Okay, so this will be made available for you, and then I also have another review sheet that will be available for you in course resources. I'll have a folder that says final exam review, and I'll put these things in it. This I think could be really helpful for you again as a study aid. It takes what you saw in that 10-page document and boils it down to 4, and it's just more of a schematic. You can write things in the margin, you can write things in the open boxes that are here, but basically it's covering the main topics in each chapter and what you should be able to understand from each of the chapters. So for example, again, like I said, I'm not going to go back. Don't worry about studying specifically the schools of jurisprudence again for chapter 1. I'm not going to emphasize that so much as you should be able to understand really broad concepts like the difference between common law and civil law. You should be able to understand for chapter 2 and constitutional law, basic constitutional principles we've talked about there, federalism and the Commerce Clause and the Bill of Rights, equality, those types of things, and ethics and social responsibility. Excuse me. You should be able to tell the difference between the broad concepts or the broad theories that are presented there. Immanuel Kant and Jeremy Bentham, John Rawls. You should be able to draw something up from those. I'm kind of hesitant to go through every single one of these things. I mean, I could have done a mini PowerPoint through all of them, but I think it's probably more to your advantage to look at that chapter review study guide that I just showed you and the updated version of it, and then look through each of the chapters and make some notes on these sheets. I think this should be very helpful to you. If you have any questions, you can fill in around this, where there's space on each of these. Let's see if something else I just want to point out specifically that, again, the emphasis here for your final exam, constitutional law, you need to know general principles of our system. Difference between common law and civil law is significant. You should know something broadly about ethics and social responsibility, and be able to apply ethical standards to a given situation. Let's see, administrative law, probably less of an issue that we'll talk about here. Dispute resolution, you should definitely have an idea of whether a case should go to court or not, and if there's some alternatives to it, why you would justify whether a case should, whether it should go to court, or whether there's an alternative that would be more realistic. We spent a lot of time on torts in our trial, intentional torts and negligence and
emotional distress, whether it was intentional infliction of emotional distress or negligent infliction of emotional distress, all the requirements that are necessary for negligence and intentional torts. We've certainly talked plenty about those things. We should definitely have a good understanding of that. Strict liability is significantly different from negligence. Remember, you don't have to, I want to reiterate this because I think some people are a little confused about this. Typically, people refer to it as your textbook notes as liability without fault. Either a statute or a prior case law establishes the requirement that a company is going to be held strictly liable, and it's companies that sell products, not services. Services don't apply here. Companies that sell products, and it may be sometimes that they could be dangerous products or dangerous operations, such as mining, blasting, those types of things. I put here, it says, consider the recent cases. There were some, the raw eggs, the eggs that we had a national egg recall and the peanut butter recall. These things where people got very sick. Those are products liability cases, and in products liability, you've got all sorts of defects, different types of defects that can occur, manufacturer's defects or design defects. There's a lot of different defects that a business can be strictly liable for. And the significant thing to remember in this area under Chapter 7 is it's the entire chain of distribution. So if the manufacturer makes a particular product and it's shipped by someone and it's stored by someone else and then it's in a retail store finally before you and I buy it, everyone along that whole line from the manufacturer on can be held strictly liable for any injury if something happens with this product that we now use. They're all responsible. Criminal law, going into Chapter 8, we went through a lot. I went through the criminal procedure aspect of things, the A, B, C, D. Remember, arrest, booking, and the charges, and then the defendant's arraignment. Those are the four main aspects of criminal procedure prior to a criminal trial, if there is to be one. You know the different types of crimes, felonies versus misdemeanors. Felonies, a year or more in jail. Misdemeanor or minor cases. We have infractions that are for traffic violations and things like that are minor, even more minor typically than misdemeanors. Let's see, and remember with crimes you have to meet all the elements of each of the crimes that someone is charged with in order to have them be convicted of that. Under contract law, chapters 9 through 13, there's a lot of material there, but remember I've given you the CALC mnemonic device to sort of help you along the process when you're looking at contracts. It simplifies things grossly, but in each contract there has to be consideration and agreement between the parties, a meeting of the mind between the parties, which is offer and acceptance, and they're talking about the same material product or service that's being basically bargained over. It has to be illegal, and the parties have to consent. They have to have capacity to be able to consent to what the contract is that's being made between the parties. When it comes to remedies, we have all different types of remedies. Compensatory damages, just like we saw in torts. Consequential damages for anything that's foreseeable that comes out of the breach of contract. Liquidated damages when it's very difficult to ascertain what they're likely to be. The liquidated damages are set forth in a contract before it's made out. Often that's before it's actually not made out, but the liquidated damages are actually included as a clause in the contract between the parties that are spelled out. Chapters 14, 15, and 16. 14, real property. We didn't go through all of this. We went through the main definition of what real property is, what it includes. It's everything that's attached to the land and on the land, air rights above the land, mineral rights and water rights under the land, plant life, all those things. Fixtures are things that are attached to the land. And again, how we looked at this were present interest and future interest. Present interests in land have these three different titles: fee simple absolute, which is the strongest, non-questionable, typically ownership interest. People can certainly fight over the right to it, but if you have a fee simple absolute, that's the strongest ownership interest. available to you that's present. A fee simple defeasible means it's qualified somehow by some requirement. Something has to happen in order for you to be impacted, to detrimentally not be able to have the land. It's limited by something. It's not as grand as the fee simple absolute is. Life estate, you can have it for a period of time of your life, or measured by someone else's life. And then future interest, you have an interest that these reversion and remainder. It's again, property can revert back to the original owner or their heir if a certain condition occurs. The remainder, it may be that you offer a life estate to someone, and the remainder of the interest in the land, it goes on to someone else in another form. And so those are future interests. You don't take them today. We didn't really go through tenancy and the different aspects of joint tenancy and tenancy by the entirety. There's different forms that are there, and when someone dies, who is when you have multiple owners and then someone dies, who has a right? Rights of the survivors. What do they get? That's spelled out in your textbook. Nor did we go through things about recording statutes, where you have to record the deed for land that you own. It's best if you do record it. In some places, it's specifically required, depending on the jurisdiction. Easements and adverse possession, again, we didn't cover any of that in class, so don't expect to see anything specifically there. You might be able to apply it if you did read that material and you want to apply it to an essay or a short answer question. You may feel free to do that, but we didn't go over it in class, so I'm not going to hold you as responsible for that material. Chapter 15, personal property. We did talk about all this. We talked about the definition of personal property and gifts of personal property. Well, what that means is basically a gift. If you're looking back again at contract law, you don't have any consideration involved in the situation, so that's considered a gift. How do people acquire title to personal property? Often we look at this the definition based on common law, looking at lost, mislaid, or abandoned property, how the original owner may or may not lose their ownership rights. Depends on that classification of the property. Bailments, we talked about that. Remember, bailment, the simple example is your dry cleaning. You take your clothing to the dry cleaner to be cleaned, and you are the bailor. The dry cleaner is the bailee, and they're supposed to return your garment, your clothing, in the same form that it was when you brought it in. Obviously cleaner than when you brought it in, but the same condition. So there's an issue about negligence and responsibility with the property that's been handed over to them. The last thing here is stray statutes, and the stray statutes deal with things when people lose or mislay property, what the requirements are, how long it may be considered to be no longer the original owner's possessory or ownership interest in it, depending on what the statute says. We talked about that in our PowerPoint on that subject. Employment law in Chapter 16. Again, being able to define what employee and what the employment relationship is. When we look, there are three different categories we probably talked about in class: an employer-employee relationship, independent contractor relationship, and then the principal-agent relationship. And all those are significantly different as to how you would classify the parties. And then you get here to the types of agency that are involved when we look at different agency relationships, principal-agent relationships. We talked about that. Express agency, implied, and parent, and by ratification. And then also related to that was the disclosure of agency. And if you don't disclose that there is someone you're acting as an agent for, the question as to how much liability there is on the contract all revolves around how much is disclosed by the agent to the third party who's involved in this, other than the principal. So also when we discussed things on employment law, I went through some basic slides as to who may work and when work may be done, what type of work can be done, and they're all statutory requirements that are fulfilled in those areas related to minors or related to time of day that minors can work, those types of things. And then types of work that require licenses. I think I gave you the example of someone doing a perm on someone's hair, or a dental hygienist with their hands in your mouth. There are obviously licensing requirements for those types of things. And so statutory authority for a lot of types of jobs, and whether that should be required or not is up to the local jurisdiction in those cases. Also, where and how work is done, there's Occupational Safety and Health Administration, OSHA, safety requirements, minimum wage, overtime, all those things that you see on this sheet are all significant issues that arise in employment, and all have some statutory, federal and or state legislation involved in regulating employment in those ways. Then you see a whole list of, under discrimination, a whole list of legislation that you should be at least broadly familiar with. Civil Rights Act of 1964 prohibits discrimination on the basis of race and gender and nationality and all that. And so it's really worth taking a look through again at what the requirements are of that and how that can be applied in a particular employment setting. And the last piece we talked about in employment law was on vicarious liability and the responsibility of the employer for actions of the employees. And the magic words here that I told you were scope of employment. So as long as the employee's actions are within the scope of the employment, meaning that they are in the normal course of duty for the employee to be doing for that employer, then the employer is going to be responsible for any acts or failures to act that the employee did in that position. So that's a real brief review, obviously, and like I said, I will post all this for you, so you have this sheet available to you, and the other study guide, and you obviously have this integrity lecture to listen to again if you need to, but that's the basics of what to do for the final exam. Okay, thank you. And thanks again for a good quarter, too, for all of you.